Welcome back to another episode here on Money Matters Radio, the Ross Mortgage Real Estate Matters Hour. I'm here today with attorney Mike Gorman. How are you doing today, Mike?
Very good, Bob. Thank you for having me on.
You're very welcome. Mike, your offices are based in Holden, correct?
That's right.
And what would you say is the most important mistake or the most important thing people should keep in mind when they're getting ready to buy a house? Because I know you do a lot of real estate closings. When
they're looking to buy a house, they need to put together a good team: realtor, mortgage broker, attorney. That, in my opinion, is the most important thing when you're purchasing a house. No doubt about it.
Right. We find that I tend to agree with you. The most important thing is that you have a good team, and it's not just a loan officer and the attorney, but you have to have the right real estate agent, the right home inspector. It is the biggest purchase that people are going to make. For most people, it is the biggest purchase they're going to make in their lives. And it's not just the purchase of the house that's important. It's protecting that investment over the long term. What would you do, or what would your advice be to most people in terms of protecting that investment?
Well, the first thing that anyone should do when they're purchasing a property is to definitely make use of the homestead designation. That's the first thing I would do, and that's something you should be doing as part of your purchase. Once you've purchased the property and you have that homestead designation on the property, it's a good time to see about doing an estate plan. Mm-hmm. If you have not done an estate plan in the past, you want to be able to provide some protection to the house. You want to be able to name beneficiaries to receive the property if something is to happen to you. If you have small children, you want to make sure that property is protected for those kids should something happen to you.
And before we go too much further, you mentioned the homestead protection there. For people that are unfamiliar with that, could you explain in layman's terms what that is?
It's just basically a protection from claims against the house. So let's say you have medical bills that you cannot pay due to a lapse in employment, or you are in an accident and your insurance doesn't cover that accident. The classic example I will give people is you are driving down the road, you are in an at-fault accident in which you are at fault, and your insurance coverage perhaps covers $100,000 in bodily injury, and it turns out the person who you've hit is hurt badly.
Right.
That person cannot then sue you and recover against your property if you have a proper homestead on the property. The current homestead you get from the state for free only covers $125,000 of equity. The one you can declare covers $500,000 in equity. And I urge people that is absolutely the most important thing to do. It only costs $35 to record this instrument, and most attorneys charge no more than about $100 to do this homestead. You can even do it yourself by printing it out off a Registry of Deeds website.
Mm-hmm. So for $135, you can protect up to $500,000 in equity?
That's correct.
And is it something you record once that protects you for the life of the time you have the home, or as you build equity, do you have to record it again and again?
Nope. Now you just have to record it initially, and it protects you until that property is no longer yours. In fact, the way the homestead is designed now is the new designation also allows you to protect proceeds from a sale for up to a year, as long as those proceeds are earmarked for another principal residence. So it's just an absolute no-brainer for people.
That makes sense. What else? What else would you recommend people do to protect their house? Now, a lot of people ask me when they're going through the start of the process about owner's title insurance. Could you tell us a little bit about what that does?
Of course. Owner's title insurance covers a lot of different areas. Some of it is mistake-based. So let's say you hire an attorney for your purchase, which you absolutely should be doing. There will be a title search that is done by the bank and it goes back 50 years. And the search is reviewed by the bank's attorney, your attorney, which may be the same as the bank attorney. Mm-hmm. But what I'll say is that not everyone is perfect and mistakes can be made. Now, that doesn't mean that it happens often, but occasionally there'll be a mistake made on the title abstract, whether it be by the attorney's office or the people who search the title. They may have missed an old mortgage. They may have missed an easement on record. They may miss a restriction. Owner's title insurance will cover that. They will come in and they will make sure that when you go to sell or refinance, that problem is taken care of by the title insurance company.
Right.
Also, what it covers against is deeds that were signed under duress, incapacity. If you were not 18 when you signed a deed or a mortgage, that's something that cannot be spotted on a title search. There's no way to determine whether someone was signing something under duress, or if they were not of age, or a mistake was made.
Right.
In that case, title insurance would again step in and cover the situation. There's also expanded title insurance, which will cover everything from boundary disputes to tax disputes, et cetera, et cetera. That's another thing that you purchase once. And as long as you own the property, you don't need to purchase it again. So again, when I purchased my property, I bought it for friends and family of mine. When they buy it, I don't even have the argument with them. I just say, you need this. It's a no-brainer. It is something that you should never go without.
Right. So are there times where it would be more important to do this as opposed to others? Let's say you're buying a resale of a property that was built in, say, the 60s or 70s versus a house that's built in a new subdivision. Are you risking, or do you have more liability on something that's newer as far as mistakes that could have been made, or is there more risk on resale from 30, 40 years ago?
I think if you are purchasing a property that is coming out of foreclosure, bankruptcy, a short sale, any of those situations, it's foolish not to purchase that title insurance.
Okay.
It is a major mistake.
Right.
There have been rulings that have come down from the courts on bankruptcy cases, which have caused all sorts of problems with titles over the last few years. And if you did not purchase owner's title insurance, you were kind of up the creek. If someone comes to me and says, I'm purchasing a property from my family's owned it for 75 years, am I going to put up an argument if they don't want to purchase owner's title insurance? Probably not. But if it's, there still could be an issue with duress or undue influence or probate issue that goes back more than 50 years. Remember that under the Massachusetts title standards, we only have to go back 50 years.
Okay.
So if there's a problem from even beyond that, and that's happened before, it can come back to bite the person in the behind.
Okay. And the risk isn't so much that they lose their house, it's more the legal costs involved in defending it, correct?
Both the legal costs and, if someone comes back and says, hey, someone didn't search this probate file correctly, I'm a heir of the previous owner and I wasn't paid off by the estate, this person could own a 1/3 interest or a half interest in your house. And that could be a huge problem. And if you don't have owner's title insurance, you're then going to be looking to either sue the attorney who did your purchase, and perhaps this comes back 10 years after you've purchased and that attorney no longer practices or has passed away. So there's no insurance to recover from. You could be up the creek. It's a lot easier to buy this policy that will cover you as long as you own the property.
Okay, good. Let's talk about the importance of estate planning.
Vital. I tell people one of the best times to do an estate plan is after you've purchased the property.
Okay.
If you have an estate plan, I tell people every 3 to 5 years, just check in with whoever did it. Or if your attorney's retired or no longer practicing, to speak with someone who is well-versed in that field. Because laws change. In 2012, Massachusetts instituted what's called the Uniform Probate Code, which brought a lot of changes into estate planning and trusts.
Right.
For instance, there used to be one way to probate a will. Now there's multiple ways. You can do it informally or formally.
Okay.
You can do a supervised administration from the court or an unsupervised administration. You just want to be up on the latest changes. And the other thing that changes, it seems like every couple of years, is the estate tax. Right now, federally, most of us, unfortunately, don't have to worry about it. It's over $5 million exemption. However, people tend to forget that Massachusetts has an exemption of only $1 million. A lot of people don't realize that on paper, they're millionaires when you add up equity in their property, their retirement plan, and life insurance. So you could have someone with a couple $100,000 equity in their property, a couple $100,000 in retirement, and they have $1 million life insurance policy. On paper, if they passed away at that moment, they would have a taxable Massachusetts estate, and that can be a problem.
And I bet a lot of people don't realize that they're not taking into account the life insurance policies.
That's correct, and there's easy ways to kind of, what I say, fix the problem of life estate, turning your estate into a taxable estate. We do irrevocable life insurance trusts, which are inexpensive, and if you survive 3 years after taking this policy out of your name into this irrevocable life insurance trust, that money is no longer counted in your estate. So for people whose life insurance policies are taking them over the exemption amount, that's a nice quick fix to their estate tax liability. And the problem with Massachusetts is they don't tax you from $1,001,001 upward. If you have a taxable Massachusetts estate, they start to tax at your first dollar.
Wow.
All the way up.
So it's not just on the amount over $1 million.
That's correct.
Oh, see, that's another thing I wasn't aware of.
Yeah, it's federally is different. They tax you for the amount over the exemption amount, but Massachusetts does not.
So you mentioned before we went on the air today that you actually have a free report that you'd like to offer our listening audience today, and it's about the 5 common mistakes people make with estate planning and how you can avoid them. So if you're listening now and you'd like to get a copy of that free report, you can email Mike at mike@mikegormanlaw.com, and that's Mike spelled M-I-K-E and Gorman Gorman. So it's Mike at mikegormanlaw.com, or you can call his office in Holden at 508-438-1198. Again, it's 508-438-1198. And don't forget to tell him that Ross Mortgage sent you, that you listened to the Ross Mortgage Real Estate Matters show on the Money Matters Radio Network. Getting back to probate, how do you avoid probate? Is it just strictly with an estate plan, or are there other ways to do it?
There's 2 ways you can avoid probate. Well, actually 3. One, you can die with nothing, which is the way you don't want to avoid probate. But
Right.
the 2 ways we advise people, or the one that I recommend, is doing a revocable trust,
Okay.
which a lot of people call a living trust. Now, it's not appropriate for everybody. For instance, I had a client come in who was selling her property, and I was looking at this 45-page living trust she was given, and this woman only had about $25,000 in assets outside her house.
Right.
And in the letter, the attorney had said, I only received X amount of money from you. You'll pay the rest of the money when you sell the property. So I didn't really understand why she was paying $2,000 for this document when she only had $20,000 in liquid assets. That to me is inappropriate. But for people who have substantial assets, living trust / revocable trust is not a bad idea. What you do is you title your belongings, house, belongings, whatever you have, in the name of, let's say, the Mike Gorman or the Bob Gallagher Living Trust. When you pass away, as long as everything's entitled in the name of that trust, we don't have to go through the probate process, which typically saves anywhere from $3,000 to $4,000 upwards. For a very basic estate, it's going to cost you $3,000 to $4,000, and in some estates that are complicated or have a lot of assets, you could be paying $10,000, $15,000, $20,000 in probate fees to the attorney and to the court. That does not sound like a good idea to me.
No.
The other thing with probate is creditors have a year to make claims against your estate, so you can't really distribute any of the money until a year has passed, or you shouldn't. Good practice is not to distribute that money. In a revocable trust, that those assets and money is available immediately. So for small business people, that's vital to have some kind of trust that works that way.
Right.
The second way to do it, which is an easier way for people who have maybe limited assets and we don't want to take that expense on, make bank accounts payable or transferable on death. That avoids probate. What we could do if you have a house is we could do what's called a life estate deed, where you transfer the property to whoever you want it to go to, maybe your kids or nieces and nephews or grandkids or whatever, but you're only transferring the interest that exists after you pass away.
Right.
So as long as you are here, it is treated as your property. Unfortunately, you still have to pay taxes and homeowners insurance on it, but it's your property. And when you pass away, the property goes to whoever you've named. And the plus of this also is that the remainder interest owners get a step up in the basis of the property. So if Grandma bought the property in 1953 for $5,000, and when she passes away in 2014, it's worth $250,000, the people getting the property get a basis of $250,000, which means if they then go and sell it for $250,000, they pay no tax.
Oh, wow.
That's a good thing.
That's a great thing.
So that's another way we can avoid probate.
So there's a lot of advantages to getting it done ahead of time.
Absolutely, and it also avoids family disputes, which seem to come up in probate cases probably 40 to 50% of the time.
Really? How many, and I don't know if I'm putting you on the spot with this, but percentage-wise, how many people actually don't do estate planning or wills and end up having to deal with probate?
Well, a lot of people will do. Only about 40% of the public has done estate planning,
Wow.
which is crazy. As far as the people who avoid probate, out of that group of people, probably only about a quarter of them look to avoid probate.
Wow, that's crazy.
It's probate is not something you want to go through if you can avoid it.
Right. Now, would you say that everybody needs an estate plan?
Absolutely, absolutely. If you are young parents, maybe you don't have a lot of assets, you want to be able to name guardians for your children if something happens to you. If you are in a accident, you want someone to be able to make healthcare decisions for you. If you are elderly and we need to be able to have someone handle your affairs while you're recovering, maybe in a rehab hospital, you need a good power of attorney. I would say if you're an 18 or 19-year-old kid in college, let's say you play athletics or you engage in activities which may leave you sick.
Right.
If you don't do a HIPAA form or a healthcare proxy, if mom and dad calls the hospital to say, how's Junior? And the hospital will tell you, we can't speak to you because there's nothing on record allowing us to give you information on your son or your daughter. So everyone needs to do an estate plan, whether you're young, elderly, or in between.
Well, that's good advice. So before I forget, I'd like to let people know how they can get in touch with you, Mike, if they have any questions about estate planning or real estate closings or anything along those lines. Again, your office is in Holden, and you cover all of Massachusetts, or is it predominantly the central area?
We cover, I tell people I'll go anywhere from Hampden County through Plymouth County. I will not go to North Adams, and I do like the Cape, but I usually like to go there on vacation.
Yeah, I don't blame you. It's a long drive. So if you'd like to get in touch with attorney Mike Gorman, you can reach him at his office at 508-438-1198. Again, it's 508-438-1198. You can reach him by email at mike@mikegormanlaw.com. His web address is mikegormanlaw.com. And if you'd like a copy of that free report, Avoiding 5 Common Mistakes People Make with Estate Planning, go ahead and send him an email. Again, it's mike@mikegorman.law. mikegormanlaw.com. Thank you for tuning in to Real Estate Matters with us today. We'll be back with more after this.